Hello, everyone. Dennis Block. We're here on another Saturday afternoon for our Zoom Landlord-Tenant radio, and proud to be helping everyone with the information that we talk about on these shows. We do have some ground rules, of course, and that is that this information is you're hearing is not legal advice. If you do need the services of an attorney, you know what? You got to pay for one. But we do try to answer your legal questions for you. But again, it's just for informational purposes only. If you do have a case with us, I would ask that you not talk about it directly. Please call the office, and our staff, our 25 attorneys, will be happy to talk to you about that. But it's just more for general legal questions. If you do want to ask a question, then on the bottom, you're going to see where it shows you where you can raise your hand, or it might be in the reactions portion on the bottom of your screen generally. Raise your hand and I will be happy to pick on you. One of the topics I want to talk about today, which is very important, is that this Thursday coming up, I believe that's October 19th, there is going to be a wonderful trade show at the Long Beach Convention Center. This is sponsored by the Apartment Owners Association. You'll get to go out there. Admission is free. You might want to check their website out, AOAUSA.com. That's AOAUSA.com. Check out their website. You can just register there. But again, the admission is free. You're going to see literally 600-700 vendors or more who will be telling you about their products and services. You'll learn how to literally operate your building more efficiently and more economically. So I definitely recommend that. If you've never been, then you'll be amazed. And if you have been, then you know you need to come back. So once again, that's Thursday at the Long Beach Convention Center. It starts at 9 o'clock. There will be a plethora of speakers that will be speaking on different topics throughout the day. And yours truly, Dennis Block, usually they have me as the keynote speaker. I'll be speaking at 3 o'clock. I'm going to have handouts. I'm going to have beautiful girls in the booth. No, just kidding. But you'll be able to get your questions answered in person by myself and other attorneys that I have in the booth. And also you'll be able to hear me speaking. I'll be speaking at 3 p.m. So judge when you want to get there, but I will be speaking at 3 p.m. for 1 hour. So hopefully I'll get to see you in person on Thursday, but if not, don't forget we're going to be doing this Zoom Landlord-Tenant radio every Saturday at 3 o'clock. Check in on my website in case we miss one day. You'll get some advance notice on that. I'm now going to open it up to questions. Aposnas, you were here last week. Thank God you're here again. And I think I have opened it up for you. Can you hear me?
Yes, thank you so much. I have a question. I have a non-rent controlled townhouse in the San Fernando Valley with a month-to-month tenant, and I would like to be able to move in. How much notice do I need to give? And do I have to request the opportunity to do this through the housing department, or what is the procedure, please?
Well, the procedure is that you are going to need to file an application process with the city first. Once that's approved, then you'd be serving a 60-day notice on your tenant. And that 60-day notice has to be put into a proper format. But the last part of this is that you're going to need to offer relocation money to the tenant. I might add, if the tenant is over 62 and has lived there for 10 years, well, but if he had, then that tenant would be exempt from asking him to move because you wanted to put yourself in or a family member. But in your situation, as I can see your head shaking, no, then you're just merely going to have to pay relocation. Now, relocation can be anywhere from approximately $8,800 up to $24,000, depending on how long the tenant's been there, whether they have minor children or handicapped or are over the age of 62.
It's a single adult who's been there, I think 1 or 2 years on a lease and about 2 years on a month-to-month.
Well, so he's been there longer than 2 years. Correct me if I'm wrong.
Longer than 2 years, yes.
Let me see if I can find a chart real quick on that, just so you'll know exactly what that is. And let's take a look. It is for somebody over 3 years of age, and you probably would qualify for the mom and pop because you probably don't own more than 4 units in the city of Los Angeles. Is that correct?
That is correct.
So you would have to pay a whopping $9,500 to your tenant for the privilege of moving into your own unit. It's unbelievable, but that's what it is.
What happened to the 1 month return last month's rent as your relocation?
That only applies to single family homes, and you have a condo.
Oh, a townhouse is not a home.
Unfortunately, no, it's not.
Got it. Okay.
All right,
And
we are going to
So
move.
just apply to the HCIDLA or whatever they're called
Yes,
now.
you're going to have to apply to that.
Thank you.
All right, no problem. Okay, let's move on to my good friend Dina. I'm going to ask you to unmute. I'm lowering your hand.
Hi, Dennis. How you doing? Thank you for
Hello.
that in advance. I have a question which a tenant he told me that he's buying a house and then he wants to move as soon as from the lease because he has a lease till the 1st of August of next year. However, they are dragging my feet and my real estate is telling me maybe they're gonna sublet the property. If I go close to the house in a distance to watch if it's sublet or not, is that against the law? Or if I want to?
No, madam, you could stand right in front of the house all day long, as long as you're on a public sidewalk. So
Yes.
if you want to see that if strangers are living in your house, then you certainly have the right to check that out. There's no problem with that. If they are, is this property in the city of Los Angeles?
In the county, and it's exempt.
Unincorporated area of LA County?
Yes, incorporated.
Okay, but what city?
A Diamond Bar.
Okay, yeah. So if in fact they do bring in an additional person, you would have the right to serve a 3-day notice to perform or quit, giving them 3 days to remove the unauthorized person from your property. And if they don't, then you have the right to bring forth an eviction. But I mean, the issue is, I mean, do you really, what's the issue if they do bring somebody else in at this point in time? What would be?
Well, the issue is somebody I don't know, and they can damage the property, they can do whatever. But am I also, Dennis, be able to take pictures of their car or of those individual coming in and out of the property?
Yes, ma'am. Anything that's in the public view, you can take a picture of.
Okay, and even if they are entering the garage or coming out of the garage of the property?
Again, anything that's in the public view, we can say it a few different ways, but if it's in the public view, you have the right to take a picture of them to see who's coming and going. And if you do see that strangers are living there, and I think it's going to be obvious because, you know, your neighbors will tell you that, hey, you know, those tenants, your tenants moved out. So you'll be able to determine that pretty quickly.
Right. And I just heard you, you told the lady ahead of me that, because I have a condos, 2 condos. Condos are not considered single family homes?
That is correct. A single family home is a single family home. A condo, obviously, you're on one lot with a bunch of different owners. Each of you have your own assessor parcel number, but they have a distinction. just the way they wrote the law, between single-family homes, condos, and townhouses. Now,
But
in all of those situations, whether it's a single-family home, a townhouse, or a condo, you still have the right, regardless of what jurisdiction you're in, you still have the right to raise the rent as much as you like, as long as you're on a month-to-month tenancy.
so, I mean, I'm exempt. That got nothing to do with the exemption of the property if it's not a house or it's a condo, let's say.
Correct. So you can raise the rent, but if you wanted to move in, you'd have to pay a higher relocation.
Oh, okay. And I have one tiny question. Can I?
Yeah,
Another
of course.
general question. Thank you so much. Actually, you know, when you have a tenant is moving at the end of the lease, and then you have to give them something called the right of inspection 2 weeks prior to the end of tenancy. And if they agree on that, and then there is something need to be repaired, and they go and repair it, are they still obligated to leave by the end of tenancy, or they can claim, you know, I didn't finish, all those tricks of tenants?
Well, I think those are two separate principles. If a tenant's going to give you notice that he's going to vacate, okay, then he, not you, he has to inform you that, hey, I want a pre-security deposit inspection. In other words, that I want to at least 2 weeks prior, 2 days to 2 weeks prior to vacating the unit, I want you, Mr. or Mrs. Landlord, to come with me, point out what you think you're going to be deducting from my security deposit to give me a reasonable chance to fix it. And if I do fix it, then technically you can't deduct it from the security deposit. So those are really two separate issues where he's going to want to stay over. If he does stay over, in certain jurisdictions, you would be able to bring forth an eviction based on the fact that, hey, you said you were going to move and you didn't. But incredulously, in the city of Los Angeles, if a tenant sends you a notice saying, I'm leaving, I'll be out by October 31st, and this is my formal notice, and he has it notarized. If he doesn't move, you do not have the right under the rules for the city of Los Angeles to evict that tenant. Because you see, in the city of Los Angeles, there's 12 reasons to evict, and that is not one of those 12 reasons.
Yeah, actually, I gave them the notice and say, you know, I'm not going to be able to renew or extend the lease by the end of this year, which is 31st of December, end of tenancy. So I still be obligated to send them a notice about the right for inspection 2 weeks.
No, that's the tenant's responsibility to tell you that he wants an inspection. Okay.
Oh, because my real estate agent, she sent me like a notice by the CAR, the California Association of Realtors, saying that the landlord is sending that to the tenant and telling them, you know, I'm being able to do this date and 48 hours prior, blah, blah, blah. So
I understand that. I'm sure that your real estate agent is probably very experienced in terms of selling property, but leave the law to me, my love.
of course, that's why I want to ask you. Of course.
And that is, it's the tenant's responsibility to ask for a pre-security deposit inspection.
So I don't have to send them
darling.
anything.
We're going to move on because I want to make sure that I get to everybody. And now I'm going to talk to my good friend Steve. Steve N. I'm going to ask you to unmute.
Hi.
Hello, Steve.
Okay, my question is, I have a condominium that's built in 1974 here in Studio City. I have a tenant in there that's been there 10 plus years. They're paying the rent, no problem. But the lease is really old and I want to write a new lease based because there's so many new laws. Can I do that? And does the tenant have to sign it?
You certainly can do that, but you can't force the tenant to sign it. Okay. So you're in the city of Los Angeles. All properties are now subject to the city's new just cause audience. So you can't, let's see here, you can't ask them to sign a new lease or have any control over that.
Okay, but they can do it voluntarily if I provide it.
Yeah, I would say, hey, we need a new lease. And, you know, you can do a little bit of negotiation in that by telling the tenant, hey, I have the right to raise your rent. And I could raise it $500, or I could raise it $300. Now, I'll only raise it $300 if you're willing to sign a 1-year lease, a brand new lease. So you can put some incentive, but if you don't want to sign it, no problem. But then I'm going to get a trusty old rent increase notice, and I'm going to dust it off, and I'm going to write in $500 that you have to pay.
Got it. And I'm not limited on how much I can raise the rent because it's a condo, even though it's built before 78.
You are not limited. You are free to exercise your contractual rights.
Thank you.
All right, thank you. Okay, let's move on. I'm going to go, I think, to something called iPhone. Hello there.
Hey, Dennis, let me ask you, what's your opinion on having Prop 19 repealed?
I'm not sure what you're referring to as to Prop 19. What is the statute?
Proposition 19, the death tax?
Oh, that I don't really know. We're dealing with landlord-tenant issues, and let me tell you how varied those are. But in terms of those kinds of questions, if you want to go into any kind of estate planning or anything like that, I do have a wonderful attorney, which I will mention right now. His name is Michael Elson, E-L-S-O-N. So look him up. I don't have the number handy, but look him up and he can give you these answers. But I appreciate that.
All right, thank you.
Okay, let me move on now to Michelle. How are you, Michelle? You're going to need to unmute.
Hi, Dennis. Thank you.
Hey there. How are you, darling?
I'm good. Thank you. My question is, I live in Los Angeles, which is under rent stabilization ordinance.
I've heard that.
I live in the front house, and my ADU, which is a garage conversion, had a tenant. Now I'm trying to sell my property, and I offered the tenant the the notice for the buyout cash for key notice. She's not signing it. Am I, or can I ask her to sign it, or we cannot force her to sign it?
Well, we can go over there with a bunch of big guys and just push her around,
Yeah.
No, you can't do that. Well, that's why they call it like a buyout or a voluntary vacate agreement, because it's voluntary. So this is an ADU. Was the ADU built in the last 15 years?
The garage, or when I constructed it?
Yeah. Well, when did you get the certificate of occupancy for the accessory dwelling unit?
Oh, last year.
Okay, so that means you're not subject to any rent control. So if she doesn't want to take a buyout, okay, you have another thing that you can do, which is really good. And that is you can raise the rent. You can raise it to whatever you like. I try to keep it within a reasonable but very high level, and that might force her to leave. And you can tell her, look, you can either take my buyout agreement, we like to call them a voluntary vacate agreement, and I'm willing to give you $10,000, $15,000, whatever you think. Or if I don't get that, then I'm going to not sell my property and I'm going to have to get more rent. So I'm going to have to raise your rent another $1,500. So would you rather take the $10,000 and leave, or would you rather just pay me $1,500 more per month? So that's kind of the way I would handle it with them.
I'm offering her the 24,000, the maximum amount in there, because she has a minor. And, prior to transferring to the ADU, she used to live with me in the main house for 2 years. She's considered to be like more than 1 year tenant, no? Even if she just transferred to my ADU.
Yeah, but again, she doesn't have to accept any amount, and there is no specific amount. You said, well, with a child, it's 24,000. That has nothing to do with a voluntary vacate agreement. If you were trying to move her out because you wanted a family member to move in, then yes, then that chart applies. but it doesn't apply for a voluntary vacate. It could be, hey, will you move if I buy you a ticket to Disneyland? And the person could say yes. And then you give them the ticket, you write up the contract, that's a legal contract. But, or it could be, I'm willing to pay you $1,000 and she says, no, I'll move, but you got to pay me $1 million. So, and I'm sure if you offered her, I'm almost guaranteed, if you offered her $1 million, I guarantee you she would vacate the property. So the bottom line is you have to come to terms, but you have kind of like the carrot and the stick, if you remember that scenario, where you tell her, look, you can take my $10,000 or whatever you're willing to offer her, or I'm just raising your rent because if I can't sell the place, then I got to get more money because that's my reason for selling the place. So I think if you use that approach, I think you will do much better.
Am I not going to be charged with harassment or something if I say that? Because, you know, she's been telling me that I'm harassing her, you know, with a lot of texts and questions.
Everybody says harassment, okay? Everybody says you're a racist. Everybody says a lot of things, but it has nothing to do with reality. That's not harassment. Negotiating with a tenant to have the tenant vacate your property. That's just called capitalism, a free economy. And these people who walk around yelling harassment, they're idiots, fools, and they go nowhere with that. So based on that, young lady, I'm going to mute you now, even though I still love you, but I'll still mute you. And I'm going to move over to Carrie. And Carrie, if you could unmute yourself, I am happy to talk to you. Are you there, Carrie?
Yeah, I'm here. Thanks, Dennis.
Hey, how are you?
I'm good. How are you doing?
Good.
We're LA City, RSO, and single-family homes. During the moratorium, a lot of tenants moved other people into their units.
Yeah, let me stop you. You said two
Okay.
things that are inconsistent. You said single family homes and you said RSO.
We have
Home.
multi-units also.
Okay, so you have single family homes and also RSO units.
Yes.
Okay, and they moved extra people into your units, and under the city rules during the pandemic, you could do absolutely nothing. Now,
Correct.
what's the question?
February 1st, can we start charging for the extra tenants?
That's a
February
good
1st.
question. Under the city rules, you were entitled to a 10% rent increase for any additional person who joined the tenancy. So since February 1st of 2024, they are allowing rent increases. There was another rule that said if you were going to increase the rent on the basis that an extra person moved in, you had to do it within the first 60 days of them joining the tenancy when you knew or should have known. But I would think that any court interpreting that would state, well, since you couldn't do anything, you can serve notice now to take effect on February 1st of 2024 that your rent's getting raised, not only whatever the city says, which is currently 7%, but also an additional 10% because you moved that stranger in, which would be a 17% rent increase. Now, that's the way I'm interpreting it. And so far, no court has interpreted any of these issues because they couldn't have been raised at this point in time. So, but I think we'd be fair in giving them a 17% rent increase. But don't forget, if you're going to do that, you need to do that at least 90 days prior to when you want the rent increase to take effect.
Right. Okay. And when we do that, if we do that, are we automatically adding that person to the lease? Do we need them to sign a new lease?
Well, I would prefer not for them not to sign a new lease, just let them be there as an authorized agent. So this way you would be able to evict them when the main tenant moves. But you know, you have another option right now today. If there's strangers in your unit in violation of the rental agreement, and even though they've been there for 2 years because of the pandemic, we have been filing lawsuit after lawsuit on the basis that the tenant is unauthorized. In the city of Los Angeles, for unauthorized persons or pets, we have to serve a 30-day notice to perform or quit. But if we do that, then they got to be out in 30 days. And we've been going forward and doing a ton of successful evictions.
Okay. Kind of on the same thing, I guess. When we have new tenants move in, say we've got a house for rent and they've got 3 kids over 18, what this landlord has always done that we're working with right now he has made it so everyone over 18 has to sign the lease, not just occupants. Do you think that's a good idea?
I think
Oh.
anybody over the age of 18 should be credit checked and also be forced to sign the rental agreement. So
Okay, yeah,
I think that's wise.
that's what we've been doing.
Well, good job. How many
Okay,
units are you managing?
106.
Oh, you're a small person. No, I'm just kidding.
Yeah.
106, pretty healthy, though. I was talking with a client today who had 40,000 units. So,
Wow. Yeah.
but that's how 106 is pretty healthy.
We consider ourselves small time. They're
Yeah.
all in one spot though, which is good. We're on 8 acres.
Oh my God, that's great.
Yeah.
That's great. I'm only on a paltry 1 acre, so. But in any event, I'm gonna turn you off, young lady. Feel free to raise your hand again. And now we're gonna move over to Daniel. Mr. Daniel, I have lowered your hand, but you are free to unmute and let's talk.
Hi, Dennis. Thank you. So I'm in the city of Glendale. It looks like I'm going to be starting an eviction for failure to let me in to fix a heater, which was red tagged by the gas company. My question is, if I start an eviction and in the midst of the eviction, I know once it gets cold, he's going to call the city inspector and make me go in there and fix this heater. Will that blow up my case once it gets to the judge that the heater's been fixed?
Well, the issue is access cases are not the easiest cases to start with because it's logically difficult to serve a notice. And what kind of a notice do you serve? Do I serve a notice to perform or quit to let me in? Well, let me in when? During the 3 days, after the 3 days? So it's not like, hey, pay me the rent within the 3 days. That's easy to figure out. Or get rid of the dog within the 3 days. That's easy to figure out. But so for access cases, the way we handle them, and I'll be frank with you, they're not my favorite cases, though we tend to do okay with them, is we send the tenant a 3-day notice to perform or quit, giving the tenant 3 days to contact the landlord to tell us within a 7-day period to let us in, when you will let us in. Now, if you, and the notice goes on to state that if you don't let us in within the 3 days, then we're going to be there on the 4th day at 9 o'clock on a Tuesday, and we're going to go in. And then, of course, you take out your smartphone, and what you're going to do is videotape him either letting you in or not letting you in. But you have to understand, and you have actually talked to me personally at the office about this, that when you're dealing with an access, if you serve an access notice on a tenant that I'm going in on Monday at 10 o'clock to fix this red tagged heater, if the tenant calls you and says, don't you dare come in, your position has to be you show up at that time on Monday and you knock on the door, and if the tenant opens the door, fine. If the tenant doesn't open the door, use your key. If you don't have a key, get a locksmith. Go on in there and do what you need to do. If in fact he stands in front of the door and says, I'm not letting you in, you can call the police, depending on what jurisdiction, because some of them will come and some of them won't. And in that situation, you'll ask the police to come to keep the peace. They'll talk to the person. And during this whole time, you'll be videoing with your smartphone this person not letting you in. And that would be great proof, number one, to any inspector that says, hey, you're not fixing this. Well, you want to know why? Here, take a look at the picture. I'm sitting here with my contractor and he won't let me in. And also it would bolster our eviction action. Okay.
Okay. Excellent. Thank you so much.
All right, Daniel, you are now muted. Let's move on to a guy who I really like. And I'll tell you why, because his mother was smart enough to name him my name. So Dennis, how are you?
Hi, I'm just fine. Thank you so very much. Yes. Okay. Family. A son becomes 18. That son is now an adult. How is that? Now, I noticed that in your list of forms, there used to be adding a person to the lease. It was just a form, they filled it out, but I don't see that anymore. So that's one question, please.
Well, let's do one at a time. Number one, before I answer your question, you have to answer my question.
Sure.
What instrument do you play?
Trombone.
That's a trombone. I see the music behind you. How
Yes.
long have you been playing trombone?
Since 1959.
So would it be fair to say that you know when the Saints come marching home?
I certainly do.
Okay, that's probably one of the only trombone songs that I know.
Okay, well, that's good. That's good.
But in any event, I think that form is still on my website. I'll have to take a look for that when you're adding in another person. But I don't think there's any necessity to do that. Once you have a family and the kids were 12 years old, they've been there now for 7 years. I don't think there's any necessity to add them. In addition, if you're dealing with like a rent controlled area, you wouldn't have the right to force them to sign anything anyway. So I don't think but as one of the callers we talked about, if they come in and they are 18 or over, that's an adult. And then I want to check your credit sources on that one.
Okay, next question. Now, the family told me, well, we're going to have a family member move in. I said, that's fine. Now, is it legal for me to say, that's fine, but you're going to pay $50 more? Now, I've already raised the rent for the annual, which has been effective. So that's the scenario.
What city?
Moreno Valley.
Okay, so, and this is an apartment or a house?
Apartment.
Okay, so you're under AB 1482 statewide rent control, correct?
Correct.
Okay, so this is a little problem with the law. Does the rental agreement state that I can charge $50 if another person moves in?
Actually, it says $100, but that's
Okay, so
wait, excuse me, but that's after 2 weeks. 2 weeks, when someone moves in, 2 weeks, then you can add $100.
yeah, well, okay, yeah, because they want to make sure that, if Grandma Moses is staying with you for a couple of weeks, that you're not going to start to charge her.
Sure.
And that's reasonable because guests you can charge, but occupants are you can't charge for guests, but occupants you can. So I think that there's a problem with the state law, but I think it would err in your favor. The state law says, hey, right now it's not exactly sure what it is for Moreno Valley. It might be 9.2%.
That much.
Or 9.1% that you're entitled to per year. But in your situation, your rental agreement says, hey, look, I can get $100 more if someone moves in. And that provision was in your rental agreement from day one. It's not like you added it. So I think most courts would hold that you could raise the rent $100 or less if you chose to do so.
Sure.
But again, these rules haven't really been determined by a court of law at this point in time. And you could see an attorney making the argument, hey, the law says, 9.1%. And by the way, for Orange County and for LA County, I do know it's 8.8% for statewide rent control. But if the law says only 9.1% for Moreno Valley, he raised it more than that. How can he do that? So now you're going to have to explain your position, your legal position, that, hey, the rent was always going to be $100 more if somebody else moved in. But again, I can't guess as to the outcome because these laws are illogical, as we know, and they're totally against our free economy. And when you create an illogical law, you have all these court cases that come up where nobody knows which way a court's going to deal with it.
Okay, and then I
would take a chance though, if that's the answer to your question.
And basically I'd just, if I could, yeah, please, as you go looking through your list of forms, I looked on that page. I did not see the form where it says adding additional person to the lease. It would be a separate form.
I'll have to look for that. And I know I'm doing a little work on my speech for the Long Beach Convention Center on Thursday at 3:00. So as I'm looking through forms, I'll look for that one and I'll post it if I have it there.
That'll be great. Appreciate it.
Thank you so much.
Thank you.
And I like your name, by the way.
Thank you too. I like yours too.
Okay, let's see, we've just muted him. I see, well, Michelle, I have iPhone. Let me see if there's anybody new here. Okay, let's go back to Michelle. Michelle?
I'm sorry, Dennis. It's my first time to join, so I haven't heard if, you know, LA, you know, my situation, if I belong to the mom and pop landlord or.
Well,
the
in what context, darling?
Oh, like, you know, since I live in the front house and my ADU is in the back, am I considered a mom and pop, or I am really like,
But in what context do you want to, if you wanted to have,
oh, if you wanna offer the buyout,
okay, a
for-
buyout again is voluntary. It could be, remember I told you, it could be a ticket to Disneyland or it could be $1 million. So it
no,
has
because
nothing.
I talked to the LA housing department and they gave me like the table form, and it shows there that, you know, for studio or 1 year less tenant, it's only like 20,000. But if it's 62 with minors, I
Okay,
mean 9,000. But if it's 62 with
I
minor, it
know
will
the-
be 20,000.
Michelle, I love you, but I know the form is confusing and the people who work at the LA Housing Department know nothing about what they're talking about. If you're going to do a buyout agreement, or as we like to call it, a voluntary vacate agreement, it could be $1 or it could be $100 million. And both of those would be legal if the tenant signed it. Okay, so there's nothing more I can tell you on that. That's what the law is. There's no specific amount, so you don't have to get to quote the mom and pop exception, because there is no specific amount. We do buyout agreements for 5,000, for 4,000, for 1,000, or we've done it. I did one in one of my buildings for $37,000.
Yeah, because she called the
asked the
housing
tenant.
department, Dennis, and she was telling me that I should be paying her the 24,000 because of her minor.
But she can ask for anything. She doesn't have to say 24,000. She can say, I want 50,000 to move, or guess what? I'm not moving. That's why it's a voluntary vacate agreement. Okay.
I see. Thank
All right,
you.
sweetheart. I'm going to mute you. And now we're going to move over to iPhone. And by the way, we got people here, but I got to get some more questions. So iPhone, are you up? Can you hear me?
Yes, I
Thank
can.
you.
Can you?
Yes, I hear you. Are you in the car?
I am in the car.
Are you driving right now?
No, I'm not. I'm parked.
Oh, good. Because I
So-
don't do personal injury law.
No worries. So I have two questions. One is piggybacking off of the lady about if they can move in tenants. So after February 1, they cannot move in new tenants, correct? It's just up through that limit.
Okay, first of all, we talking about the city of Los Angeles?
Yes.
Okay, in the city of Los Angeles, if a tenant moves in, a new person today, we have the right to evict today. We don't have to wait till February 1st, period. And we're
Okay.
doing a ton of evictions on unauthorized persons who moved in a year ago. And now we're starting these evictions right now, and they're perfectly legal and we are successful.
Okay. And then a lot of these laws that they're passing, it sounds like they're just making a mockery of people. And the reason I think they're able to get away with it is because the reaction by landlords is mute. No one's doing anything about it. Are there any court cases that you think are going to end up in the Supreme Court and to put a stop to these and reverse some of this stuff?
Right now, there is a case pending in front of the Supreme Court, which we're hoping they will accept. It deals with a New York rent control law, which would have dramatic effect on the laws around the country if that passes. There's two current lawsuits that one of the apartment associations has brought forth dealing with the city of Los Angeles and the taking that they did. They stole our money literally for 3.5 years, stole our money, wouldn't allow a rent increase for 4 years, notwithstanding the situation dealing with inflation and excess costs for us to run our buildings. So hopefully those two court cases will be successful. They're also attacking part of the city's rules where if I'm asking a tenant to move and lawfully raising the rent more than 10%, that now I've got to pay this tenant relocation money if he chooses to move. These are all illegal laws. The city council had basically knew what they were doing was illegal, got advice from the city county council, or the city attorney's office, and chose still to pass these laws. So hopefully these laws will be in favor of landlords, and hopefully the big one, that's what's sitting in front of the Supreme Court, that they will rule on this.
Okay, so if that passes, or it's conservative bench, right? So do you think all this stuff is gonna get reversed at some point?
You know, I think when you saw what happened with Roe versus Wade, I think some of these judges are a little bit gun shy to now take on rent control. But you know what? All you have to do is follow the law, follow the Constitution. Where is it in life that our industry, the income property owners, are the only ones, the only industry of all the industries that exist in the United States, that we're under price controls, that we're told what we can do with our own property? This is insanity, ladies and gentlemen. And if you want to hear more of this, and you want to hear how the city of Los Angeles is definitely screwing us again, come on out on Thursday, the 19th of October. I'm going to be speaking at 3 o'clock. You'll actually get to see me, and this is going to be unbelievable. You're going to get to see me in a suit and tie. Okay, so this is going to be crazy. So anyway, but I do enjoy doing these conferences, and there will be a ton of people there. Okay, thank you very much. I am going to move on. Let's see. That was just iPhone. Let me turn you off, Mr. iPhone. And let's go to my wonderful person, Quiza. How are you?
Hi, Dennis.
Hello.
Question. My house is in LA and it's on RSO property. It's 2 properties there. And if I want to move in on the front house, she's been living there for more than 10 years.
Is she over 62?
To be honest, I inherit those houses and I don't have her information. She won't provide it to me. She will not sign a new lease.
Guess what? If you don't know whether she's over 62 years of age or older, if you call my office on Monday,
I already did.
well, I can tell you how old she is. And not only can I tell you how old she is, I don't even want you to tell me her name, but we're that good. Don't tell me her name, and I will tell you how old she is. How's that? So call me on Monday. And by the way, if you do have questions, you know, I'm kind of crazy. So I actually get to the office at 5:30 a.m. and the phones are jammed. But if anybody wants to call, and this is don't spread this around, only the people here. But if you call just between 7 to 8 a.m., 7 to 8, don't do it other than 7 to 8. I will answer the phone if you hit my extension, which is 1001. That's 1001, but only between the hours of 7 to 8. If you call at 8:01, I will smash the phone down. Now, I'm there all day long, by the way, but for my close clients who love me and come to my Zoom Landlord-Tenant radio podcast, you use that extension. You'll get me between 7 to 8 a.m. Monday through Friday only. I will answer the phone, and I'll answer a quick question for you, or in case you want to start a case. I am going to move on. I feel like there is a flower coming up here, and I will ask Daisy to unmute.
Hey, Dennis, thank you. Thank you for having me, and thank you for hosting.
Yes.
I wanted to ask you about rental agreements going forward from the COVID epidemic. What protections should we as landlords be including in our future lease agreements? I have properties in LA City that are RSO. So I'm trying to protect myself as much as I can, but I'm just wondering if there's any new clauses that you recommend us putting in our contracts.
First of all, I want to ask you, are you a decorator?
No, this is my beautiful Zoom background. It's not.
Oh, that's not even real. Look at you sneaking a Zoom background behind you. What would I see if I didn't? A bunch
A
of
white
garbage
wall.
cans?
No, just a white wall.
Oh my God, very cute. So everybody, in case you don't know what she's done, she's imported a background that Zoom lets you do. So you can pretend you're like at Niagara Falls, and you picked a really good one because I was trying to figure out what you do for a living. You know, I have a rental agreement on my website. The Apartment Owners Association has one. There's other apartment associations, and they generally are all up to date and have clauses in them that generally protect yourself. You want to have certain clauses that I just recommend that, for example, that the tenant must is required to maintain personal property insurance, and also so that if in fact something happens in the unit and his treasures are destroyed through no fault of his, there's, let's say, a flood in the unit and the water is cascading throughout the unit, then he's going to obviously want you to reimburse him for his personal property, you know, his 80-inch OLED TV and all of his equipment, and you have to then point him to the provision in your rental agreement that says, hey, you had to maintain your own personal property insurance and that you can't sue me for that. So that's really a good clause. It should also state that if you have to temporarily move because, hey, I got to take care of the flood, and I know you had nothing to do with it, then in that situation, you're going to only be compensated by not paying for the rent for how many days you're gone. So if you're gone for 10 days, I won't charge you 10 days rent. But for example, if you didn't have that, I know my daughter, for example, she would say, oh, sure, I need you to put me up in a hotel and my minimum standards is 4 Seasons or possibly Ritz-Carlton. I mean, that's my daughter. You know, I'm good for Hotel 6 myself, but so you want to make sure those clauses dealing with that they have to have personal property and reimbursement insurance if they do have to vacate the premises. Other things that you have, which I know is in my rental agreement, is that for cases, anything dealing with personal injury, that they have to has to go through arbitration or mediation. Some of these have been held illegal, but I always like to put it into my contract. You can take a look at my contract, and most of the other associations do have that phrase in there. So, but check them out. I mean, it's varied as to the different clauses, but most of the associations, certainly the Apartment Owners Association rental agreement, which I helped co-write, certainly is an excellent agreement.
Great. Thank you so much, Dennis.
No problem. Let's see. Let's see who. Oh, you were Daisy, right? I got it. Okay, yes. Oh, you muted yourself. Good. Okay, now let's go to. Well, we can go back to the trombone. So let's do that, Mr. Dennis.
Yes. Speaking about one of your forms and
Yes.
requirement of maintaining personal insurance policy, at the bottom it says check the box may if it is rent control unit for an existing tenant. And indeed, since we're in California, it's all rent control.
Right.
So therefore it's may.
Well, not everything is rent control. For example, a single family home.
Oh, okay, I got it. Well, okay, apartment. This is an apartment,
Right.
so indeed it applies.
Okay, so the reason why we put that in is there's been case law authority that states that if a tenant doesn't get insurance, can you evict for that? And the case law authority says, no, you can't, because they don't consider it a substantial breach of the contract. So if you can't evict for it, why would I have that? And that was just answered by the last person, that we put that in there so that the tenant can't come back and sue me for his 80-inch TV that got flooded. I don't want the lawsuit. And also I don't want to have to put you up at the Ritz-Carlton or the Four Seasons because you had to vacate from your unit, maybe because we were tempting it for termites or something. So you want to have that phrase in there, and that paper that you have in your hand, that's a change of terms of tenancy. And you can serve that on your tenant as long as he's on a month-to-month tenancy, whether it's rent control or not, and that will then become effective in 30 days. Again, you can't evict for that, but you can certainly use that as a defense if they're coming after you for reimbursement.
So therefore, it is their option to get insurance, and if they
Yes.
don't, too bad.
Then it's your, don't look at me to pay you for your treasures that were flooded.
Got it. Very good. Thank you.
Okay, sir. Okay, now we're gonna go to Aposnas. I'm gonna unmute you, darling.
Hello, thank you. I just was listening to you tell a tenant to do the change of terms of tenancy on their month to month to add the protections for themselves regarding having the tenant be insured against loss, etc. If I have a lease, do I then have to wait to the end of the lease to add the protections on a lease renewal, or can I still change the terms of tenancy?
And the answer is, if you have a lease, you cannot do a change of terms of tenancy. A change of terms of tenancy are only for where there's a month to month.
Okay,
And that, of course, you can then use your 30-day notice to change the terms of the tenancy. You can do it changing the due date, for example, on a case. Or we like to have also in every rental agreement, specifically residential rental agreements, that if there is any legal action filed, then a lot of rental agreements say that that the prevailing party in a lawsuit is entitled to reasonable attorney's fees. Now that sounds like a great, perfect sentence that you would want to put in any rental agreement, but that, ladies and gentlemen, is a horrible statement to put in, because you see what happens in these cases. A lot of times tenants' attorneys will ask for a jury trial or build up a lot of costs. And if God forbid you lose, they're going to ask for reasonable attorney's fees of $25,000, $30,000. But you might say, well, yeah, but if I win, then I'm going to get an attorney fee award of $25,000 to $30,000. Yeah, you will. But how are you going to go collect on it? These people generally don't have much wherewithal. So the only one who's really harmed is the guy with the deep pockets. And let me tell you something about that. If you have no money, you can do anything you want. You can rob banks, you can kill people, you can damage property, you can drugs. It doesn't matter what you do, that does not hurt you at all. But if you have money, ladies and gentlemen, then if you look cross-eyed, you're going to get sued and it's going to hurt. So the laws are only against people that have worked hard and attained some success. It's almost like a bad
punishment
misnomer in our country now, that if you're successful, they always talk about, oh, these big corporations that have 1,000 units. What's wrong with that? What's wrong that this guy was so successful, this company was so successful that they can maintain 1,000 units, and they should be protected by the law just as much as a mom and pop owner should be protected by the law. You can't have it where there's two sets of laws, one for the rich and one for the struggling mom and pops. No, it's the same. Everybody is entitled to the same protection under the law. We have a constitution. This is built on a concept of a free economy, and everything these politicians are doing to us are just taking away, they're just etching away our property rights, and it's really bad, ladies and gentlemen.
Does your form on the website reflect the tenant insurance request and all the things, so that when I have the tenant re-up for the next lease extension?
My rental agreement does limit attorney's fees to $500. It does request that you have personal property insurance, which will cover your personal possessions, and also any reimbursement. Your insurance will have to reimburse you if you have to relocate for a temporary period of time.
Okay. All right. Well, we might have to call you at 7 o'clock in the morning. Thank you.
7 to 8, not 6.
Got it. 1001, extension 1001.
Okay.
Thank you.
Does anybody have any other questions? We still got a couple of minutes to go. One more good question. You can ask me anything. I'm pretty good with sports. I was at the Laker game last night. Of course, we didn't do so good, but it was only a preseason game, and I am predicting that we're gonna win this year. And my sympathies go out to all you Dodger lovers, because you got to wait till next year. But my team, and you've heard it from me today, what day is it? It is October 14, 2023. Write this in stone, that Dennis Block stated that the Lakers will win the championship this year. And I want you to know, ladies and gentlemen, I have never been wrong. Every year, and I will talk to you, Daniela, every year that the Lakers have won, I have predicted, ladies and gentlemen, that the Lakers would win that year. I have never been wrong. However, one small thing, I predict they're going to win every year. So anyway, let's go to Daniela as our last caller. Can you hear me, Daniela?
Yes, I can. Thanks, Dennis.
Hi.
Hi. I sent I'm not sure if you received the question, but I sent it in the chat. I have a property in LA. It's rent stabilized. I have a tenant that not every time, but when they are away, they allow guests, quote unquote, to stay in their unit. How do I caution them against doing that?
Well, when they're away, how long are they away for?
I mean, it could be a week, it could be a week and a half.
There's really little that you can do with that. For example, in the city of Los Angeles, they're considered just a guest if they're there for 30 days or less. So there's really nothing that you can do with that. You know what? You can have your cousin, your mother move in for 2 weeks, 3 weeks, and there's really little that you can do to stop that.
Do they have to notify me to say that they're having a guest, or this person just pops up?
They don't have to notify you. They can just move in. There's nothing that you can do, you know, if some guy's brother is going to move in for 2-3 weeks. But if the guy starts to live there, that's a different story. Then he's really occupying the unit. He's not a guest at that point.
Okay, got it. Thank you.
Okay, well, we're going to call it a wrap because I don't see any other questions. I really appreciate you guys stopping by every Saturday at 3 p.m. Tell your friends. Tell your neighbors.
Thank you.
Yes, because I'm happy to do this, and I actually have a lot of fun doing this. And once again, please tell everybody, come out, Long Beach Convention Center. The Big Kahuna will be speaking at 3 p.m., though there'll be a bunch of other speakers. You'll really be able to run your properties more efficiently, more economically. So I'm recommending that you come on out. And if you come up to me, I promise I'll give you a hug. How's that?
Thank you so much.
Thanks, Dennis.
Take care, everybody.
Thanks.
You
Have
too.
a good weekend.